Welcome to Interactive Legal Speaker Series presentation today. This is called SLATs Drafting Workshop, and this is a continuation. If you joined us for the 31 Flavors of SLATs in February, we talked about doing a workshop where we would go through the drafting process in a unique way. And that's where we are today. And I'm happy to be joined by Jonathan Blattmachr, Martin Shenkman, and Tom Tietz. And these are all the same people who were on the prior webinar. And we were just discussing how this one is not like an ordinary webinar where we're trying to be super precise about 17 different options. We're really showing a process here that is going to leverage technology, including AI, and perhaps give you something to think about and also help you communicate with your clients. And so that's the purpose today, to talk about this drafting process and also look at a very specific fact pattern, a couple who need to draft a trust, and we're going to use that as our example. So with that said, let me turn the floor over to Martin Shenkman so we can get started.
Marty's okay, Teresa.
Marty. Okay.
Yeah. You make me feel older than I am. So Teresa used what I think is really the key word, process. This is not intended to be a highly technical program, although in a way it really is, but it's intended to be practical, process-oriented. And before we start, I want to talk a little bit about the process that we're going to illustrate. And I think it's different than what many people use. And I think it's important to talk about in the context of what AI is doing to change drafting. So the last program that we did on, and it was Teresa's title, I give her full credit, 31 Flavors of SLATs or something like that. I had actually had AI calculate based on, and I didn't do a very accurate count, but the number of different variables in ILS that you can use for drafting a SLAT. And I think it came up that you could have 64,000 different iterations, factorial of combinations of all the different things, whether you include a HEM standard, whether you include a limited power of appointment, whether you have a 5-5 power, and whether you have loan provisions, on and on and on and on. There's a lot of variables. I think in many cases, practitioners don't draft with the full power of what ILS can do, because they create a template, and we used to do that too, but we've shied away from it, because when you have the full ILS spectrum, I don't know if that's the right word, but menu maybe is a better word, there's so many different options. What we also do is, instead of delegating to an admin person to draft a SLAT based on a pre-formatted series of decisions that we've already made, or like I said, a template, what we try to do is draft a SLAT from the full ILS template so that we can tailor the planning more specifically to the client involved. So for example, this illustration, and we're going to do another one with a very different kind of client using the same ILS template. This is an example, and we're going to go through the fact pattern of a very moderate, even low wealth client for many practitioners. But what we want to do is demonstrate the power of ILS to craft a cost-effective SLAT plan for a very lower wealth client. Now, I've heard some practitioners say, if you're under X millions of dollars, tens of millions, 50 million, whatever the number is, SLATs aren't practical because you need access. I understand the point. I'm not negating the point, but there's lots of clients that need and want asset protection planning, but are also at a much lower wealth level, so they're going to need access to those assets in retirement. A SLAT may be a good example. My preference for the type of client I just described would be to do a hybrid DAPT or SPAT in a trust-friendly jurisdiction like Alaska, Nevada, South Dakota, Delaware, etc., because it gives them more access. But for this hypothetical, we're going to assume the client understands that, but is going to forego the extra costs that it will incur using an institutional trustee, and the extra cost of having local counsel and the complexity of having a trust in Alaska. We'll still have a trust protector that can move it, and we'll talk about all that. Jonathan, just take a minute, and you can be the regular Jonathan here, and just briefly describe SLAT, hybrid DAP, SPAT, and why that may be a preferable approach. But we're not going to use it in this hypothetical because we've already met with the client, and for this hypothetical, they don't want that level of cost and complexity. And by the way, as just we learned recently in the Delaware, and I may get the name wrong, if Jonathan or Tom, if you know the name, CES 2007 Trust, the court really emphasized the fact that the DAPT in that case in Delaware was created before the business endeavor that led to the cause of action. Now, we're not doing a DAPT for this client. They don't want the cost. We're going to stick with a local home state SLAT. But getting an irrevocable trust set up years before the client is so wealthy that they feel more comfortable doing that could be very advantageous. So, Jonathan, let you give a quick explanation and some thoughts on that, but then we're going to narrow it back to a local home state SLAT.
Well, remember, a domestic asset protection trust, a so-called SLAT, is that you do for your spouse, is something that almost any married couple who are happy may want to consider. The problem in some cases is that one spouse will be giving up more than the other spouse. And even though there are studies which indicate that if you're wealthier and if you're older, you're going to have a lower risk of possible, divorce, it really needs to be considered. So I would suggest you do that. But as domestic asset protection trust is one where you can create for your own benefit in some jurisdictions, not all. California, New York, for example, you can't. If there's any way under California or New York law, if it's governing the trust, that the creditors of the grantor can get at the assets, even later down the line, you're going to have a potential problem. And there are other states, there are about 22 now, where you can create a trust for your own benefit, or as Marty suggested, start with one in a state like California and New York, and then move it to another jurisdiction where you can get asset protection, even though it may be to some degree or fully self-settled. In other words, it's a trust you've created for yourself. However, I would urge you, if you have clients that are interested in this, you don't need to consider doing that. And in fact, one of the things that you might consider is something else Marty mentioned, is a so-called SPAT, a special power of appointment trust, which you can read about in the February 2019 issue of Estate Planning magazine, where I introduced that with my two co-authors, Abby O'Connor from Anchorage and Mitchell Gans of Hofstra Law School, where we talked about it. And that's a trust which you are prohibited from ever benefiting from the trust. And so it's not going to be self-settled because you can never get the assets back from the trust in the discretion or mandatory of the trustee, but instead you grant, and I like to give 3 people who are not beneficiaries, a special power of appointment exercisable during lifetime, where they can appoint it to any descendant of, say, the grantor's mother or the grantor's grandmother or the grantor or the descendants of the grantor's spouse or people that are or have ever been married to them. And if you take a look at the commentary to section 505 of the Uniform Trust Code, you will see that that is not the kind of situation where creditors of the grantor can attach the assets because the grantor has retained no interest in it. Now, I think you're better off long-term going to a state other than one which still has a creditor access rule, as New York and California and several other states do. But if you really say, no, I want this at home, I would suggest you use a special power of appointment trust as the way to go forward, with 3 people having non-fiduciary special powers of appointment, which they can exercise in a manner so that the grantor of the trust and perhaps the grantor's spouse can benefit from the trust property.
So let me explain. Goal 1 is to illustrate how you can use the robust features in ILS and probably every document generation software, but since we're hosted by ILS, we're going to mention ILS, but these concepts apply. We're going to demonstrate a different approach to drafting in ILS. We've already talked about the idea of not just using a template or having an admin or a junior associate drafting based on preset concepts, but rather are thinking it through. And the reason that can be so powerful is you can truly tailor the planning you're doing to the specific client situation very cost effectively. Now, I know Jonathan and I always disagree. He tells me you can draft a SLAT and ILS in 15 minutes, and I say, no, it takes at least 30 minutes. But the bottom line is, we can, using a tool like ILS, cost effectively draft a pretty sophisticated trust for a very moderate wealth client and make it really make sense, and that's what we're going to illustrate. Now, the other thing that we do when we draft, which I think is different than most people, is if we can draft, and I hope it comes out to the half an hour or less that I just committed myself to, a pretty robust SLAT in 30 minutes or so, by having two lawyers, two professionals, and I know you got four now, but two professionals drafting together, you have a give and take that can be very important, because no two, you know, this must be an old joke that if you put two estate planners on an island, they'll have like 4 opinions for every question you ask the two of them. But we're always going to have different views. Now, we can discuss that, and I think you get a better result from the first draft out of ILS when you've had the discussion while you're drafting. Jonathan may have a different view than me. I'll listen to him. I may overrule him and do it my way. I may say, yeah, Jonathan, you're right, we'll do it that way. So that's another piece of the process, using Teresa's term, that we're trying to illustrate. Cost effective, even for a moderate wealth client, and very robust so you can tailor it to whatever that client situation is. Another concept, how do you protect yourself as a practitioner? How do you inform the client? And how do you do it, especially for a moderate wealth client, very cost effectively? And we're going to try to demonstrate that, and I hope it works. We're going to try. And the way that I believe you can do that is by doing a meeting when you draft. In other words, if we have two lawyers, we don't sit down at a desk with a big screen in front of us. We sit on our laptops wherever we're working from, and we draft through a web-based meeting, whether it's Teams or Zoom or something else. We record that meeting. We strip out the transcript, which is easy to do. We'll demonstrate how you do that. And literally, it'll only take you a half a minute to do. And then we have AI draft a memo to the client about the ILS drafting session. Why do we do that? Because in the drafting session, and our conversation may be a little stilted sounding when we start drafting, and we'll do that after we go through the hypothetical. But if we do it with the right approach, and it takes a little bit of getting used to do this. Jonathan has not done this before, so he's not going to be used to it. Tom and I have done this a bunch of times. We're pretty used to it. Teresa, I don't know if she's ever done it before. But if you do it well, you can get a really pretty good memo for the client out of the drafting session. And what is the benefit of that? Let me use the example that Jonathan just spoke about, but we're going to do it in a different tone and to a different degree when we draft. I know that this client, we've already met with them because we have our fact pattern or we couldn't draft. So the client meeting already happened. When we draft though, divorce is an issue when you do non-reciprocal SLATs. Everybody knows that. Jonathan is correct. The data suggests that people of higher wealth and older age and longer term marriages have a lower divorce rate. That may not be true of a younger, lower wealth couple. So the divorce rate is higher, even if we can't quite estimate what it is. So I'm going to assume in our drafting session that we talked about that at the prior meeting with the client. They made a decision they're comfortable doing non-reciprocal SLATs. And that decision may be because, yeah, okay, divorce is a risk, but getting sued could lose 100% of our assets. If we get divorced, we're only losing 50% to other spouse. And if we're both setting up trusts, non-reciprocal SLATs, there's some assets in each. My preference, frankly, would be to do a hybrid DAPT and a SPAT in a trust-friendly jurisdiction, so there's more access, et cetera, but that's not going to be cost-effective for this particular client. So when we do the recording, when we go through the ILS dialogues and menu as we go, I'm going to make comments of thoughts to the client because now I'm giving the client more options. So when we get to just on the divorce issue as an example, we discussed the possibility of using a DAPT, a SPAT, or a hybrid DAPT. And you opted for a less costly approach with home state trusts, recognizing the issue. ILS, the prompts, the boxes in the menu, the little circles you click to make decisions, those will prompt you to offer options to the client. So now you're giving the client, at no extra time than it takes to draft, through the memo that AI is going to help you create, you're documenting that you gave the client options. If the client comes back and there's a divorce and they say, hey, Jonathan, you didn't tell us about divorce. No, I'm sorry. We actually talked about it at the meeting. And oh, by the way, the memo we sent you with the draft SLAT, that discussed this issue too, as well as the reciprocal trust doctrine. We can't belabor any of these points to the detail like Jonathan did when he gave you an overview of SPATs and hybrid DAPs and stuff a few minutes ago, which is why I wanted to do the contrast. But we can get the points out so the client is reminded. Now, another point. We as estate planners are in one of the highest risk professions for malpractice claims of any profession in the country. One of the things that I know we hear everybody recommend when they talk about defensive practice, put it in writing. Clients have selective memory, and they do, and I've seen it way too many times. So by creating the memo in the way we're going to do it, I think it's very protective of you as a practitioner. So to summarize, we're going to go through a hypothetical. We're going to do the drafting session. We're going to turn off the webinar at that point, and we're going to come back in a follow-up Zoom meeting after we've generated a memo from the transcript and show you how we did that. As we go through the ILS drafting, we're going to discuss different aspects of this in a way that AI can pull it into a memo that will be explanatory to the client and helpful to you. And one of the beauties of this is you will remember very precisely what you did 10 years from now because you got a summary of what you did talk about and why you made the decisions as to which approach or options to use in ILS. And there's a lot of options. So does that make sense? Does anyone want to offer any comments?
There's two comments that I want to make about the process. Marty had mentioned that we're not using templates. We actually do use the interactive legal templates. What we've not done is created our own customized templates. Where that's important is with these non-reciprocal SLATs that we are doing here, ILS has created two different templates with different powers built into them differently, the broader access and the more narrow access. We will use those templates and we will not change the powers between them. So if we're creating two non-reciprocal SLATs, we know that there are differences baked in that ILS has created there. By not creating our own personal templates, it increases the amount of decisions that we need to make when we're talking it through. While that may seem like it's not a time saver, what it's doing is it's prompting us to have those discussions as we're drafting the trust. And some of these points could be foundational considerations. And like Marty mentioned, you have two attorneys hashing it out as you're talking about and drafting during the process. By doing it this way, you're not inadvertently creating a foundational issue in the trust that may be a disagreement later that requires you to go back and completely redraft. It increases the efficiency by taking a little bit of additional time at the start.
Marty, let me add one point to what Tom was saying. I want to emphasize that although we recommend you try to do non-reciprocal SLATs, one for the husband that creates for the wife, or the wife creates for the husband, or if it's a same-sex marriage, just for their spouse. But keep in mind that the law as to when trusts will be regarded as reciprocal, which means that the one spouse will be treated as though he or she created the trust that the other spouse created for them. There are no guarantees on that. We can give you a lot of information on it, but I think that if you really want to reduce the risk of something happen, consider doing a SPAT, a special power of appointment trust, because the commentary to section 505 of the Restatement of Trust says that there is a really no way a creditor can get it if the grantor is not a beneficiary of the trust, entitled to something at some point, because he or she will not be, because some independent person, I mean, it could be a relative, but someone who's not a beneficiary, not a fiduciary, has a power of appointment, a special power of appointment, to appoint it to the descendants, let's say the grantor, or descendants of the grantor's spouse, and people who are or who have been married to the grantor.
I'd like to cover two more points before we go quickly through the case study and start drafting. First, lots of talk in the profession right now about the risks of divorce and can you do a SLAT, can you not do a SLAT? It's not our decision whether a SLAT plan is right for the client. That's the client's decision. We can't assess the risk of divorce for the client. The client can. We can surely and should warn them about the implications, but that's then their decision. And I can tell you the idea that, you know, I can lose 100% of what I have to a lawsuit. I can only lose 50% to my spouse, and we're in this together. I get that. One of the things that's very important, Tom mentioned, ILS has developed, and I think we've had some input on that over the years, 2 different SLAT templates that they use. The difference is that ILS is baked into those separate SLATs are material, in my view. Somebody may view it differently. It's not just a 5 and 5 power in one and a levy, the levy case, limited power of appointment in the other. They bake in a lot of stuff. Those differences, I believe, will go a long way to really reducing, no one can ever say eliminate it because the law is not clear enough, a reciprocal trust challenge. And keep in mind, reciprocal trust challenges are not only by the IRS, they're by creditors. But in addition to that, they have real economic consequences. What we've been doing for a good number of years, and I wish I'd thought of this before, and we'll try to get this together to help you in the next part 2 of this session. We put in the memo to the client the differences between the different trusts and say these differences have real economic consequences. I don't want a client to say, oh, I didn't understand that. No. Not only were all these provisions in the trust that you said you read before you signed them, but we put them in the memo to remind you that they're real and have economic consequences. So we're going to address that and give you that information, and maybe that's something that will help you as well. The final piece, and I'll talk very briefly, AI is being used in lots of different ways. Tom and I just watched a fascinating video of how a firm is using Harvey to draft documents and do different tasks. And we're not going to go into anything other than drafting this SLAT now, but there's fascinating adaptations of AI to do all sorts of things. There are lots of things that doesn't seem to do really well yet. Maybe it will in a month or a year. There's amazing things it does yesterday that we should all take advantage of. But one of the
Marty,
things that I saw—
while you move forward, oh, sorry, I was going to say, while you move forward to the agenda, I was just going to add one comment about the drafting process. It kind of ties into what you said and what Tom said. And it goes back to the idea of trying to do something quickly and, within a certain period of time. And we a lot of times do talk about, set up your standard SLAT and then you can have someone in your office draft it, exactly like you said. But you're then not getting the benefit of the attorneys really thinking about each issue. So it's almost like 2 ends of the spectrum, and
Yes.
have you view efficiency, if you will, and how you want to draft. And I think a lot of people want to do it in the the quickest way. Let me set it and forget it and let my paralegal do it. And so this is a different approach, and I think people should keep an open mind for that.
Great point, and I should have said that. It is a continuum. How much customization do you do? The clients we tend to get, the extra customization, I think, is warranted. But I think what you'll also see is the approach we use is more informative for the client, more tailored to the client, and more protective, I believe, of the practitioner. That being said, there are many of all of us who do documents in a more routine way. We're cost conscious clients are the major objective, and you want to get it done as efficiently as possible. And having a preset template that you know will cover 95% of what the client wants may be fine. Let me just finish the example of Harvey, and then we're going to jump in. So what they demonstrated that they did is they said to the Harvey, which is a legal AI, which, as best as I can tell, is not available for smaller firms or solo practitioners, which is a disturbing concept to me, but so be it. Harvey, get the standard law firm insurance trust and make the following 4 changes, and here's the client data. And Harvey drafts the ILIT. What I don't love about that approach is it's really just using AI in a constricted or constrained way to do drafting the way drafting used to be done. We and all of you, if you're even half as old as I, had firm forms, and you have somebody pick up the firm form and make the changes and tailor to a client, and then the senior associate would review it, and then the partner would review it, and you go back and forth until you were done. If I'm saying to Harvey, take my insurance trust, our firm insurance trust, and make the following 5 changes for the Smith family, you're kind of really using AI in a constricted way to do drafting the way we used to. I don't see how, unless you have a really large firm and keep a current database of all these forms, and even then I don't get it. How are you going to keep current the way ILS does when they have not only whatever staff they have, but they have all these tremendous numbers of subscribers who, when we're drafting with ILS, if we see something we don't like, and we have a few to talk to you about, Teresa, we email somebody at ILS, and sometimes they ignore us, and sometimes they go, hey, silly, you didn't read it right. And other times they say, oh, that's a good point, and they go and fix it. And if it's really significant, they fix it immediately. So you may have hundreds, if not thousands of people vetting the forms. How can any firm replicate that? So if you have a firm with 10 or 15 estate planners and you have 5 different types of irrevocable trust templates, how can you possibly keep that up and have the variables that any drafting software can, ILS in our case? So I think the application of Harvey, the way we saw it illustrated, I get why it's efficient, but that's on a different part of the spectrum, and I'm not sure that's really the way you want to apply AI. So I think we've done enough background. We're going to get you a summary of all the background to demonstrate what AI does and doesn't do. And now we're going to go through the case study fairly quickly. Okay, so here's the case study. Tom, why don't you explain the case study, and I'll be back in 1 second.
Absolutely. So Jane and John Smith are a young family. So they have children, they're in their early 40s, and they are professionals that have significant income and a potential for significant growth in the size of their estate. They have about $2 million in non-retirement savings, and they are concerned, as many physicians are, about asset protection, as well as potentially outstripping the growth in the estate tax exemption. So even though that is tied to inflation, if you've got a young family that's expecting to have significant growth in their income, they are going to have eventually, potentially, the ability to outstrip whatever their exemption is going to be. So moving that a portion of that income out of their estate over time may be enough to prevent them from exceeding their exemption amounts. So the idea in this particular situation is we're creating trusts that grow with the family and that they can fund over time with capital that is supportable as not being needed to maintain their lifestyle, because you want to reduce the potential challenge that any funds transferred to these trusts are a fraudulent conveyance. So by doing it over time and in portions that are supportable as not being needed to maintain their lifestyle, you are increasing the potential for creditor protection there. One final point is, in that last bullet point, Jane's mother is older, she's not doing well, and she is not anywhere near the estate tax exemption herself. So she's not facing an estate tax, and there's significant amounts of appreciation in the non-retirement funds that John and Jane have in their personal names.
This, by the way, is why I don't agree with the comment that SLATs are only for people of some certain minimal wealth level. If we can use the tools of ILS and AI to prepare a cost-effective SLAT for somebody, give a general power of appointment, get a basis step up, the client's going to love us. You could eliminate a very substantial capital gain on a relatively modest estate. Why not do it? It's not only about using exemption, and I think that's where we have different discussions where some people say there's a range in which a SLAT makes sense. But it can work for other reasons besides the exemption. Asset protection, like for this couple, and basis step up. Tom, you want to continue? But do it quick because we want to get into the drafting.
Right, so this is actually a lot of what we were talking about. We've already had the discussion with the clients. They have made decisions. So even though they have these considerations, they have these asset protection concerns, they do not want to expend the cost that it would take to do a full, robust trust in a trust-friendly jurisdiction with an institutional trustee at this point. But they want to create a flexible trust in their home state that has the option as they grow to let the trust grow as well. They could eventually potentially move it to a trust-friendly jurisdiction. So they're getting the foundation of the plan in place now so they can use it in the future as a vehicle for their family.
Let me mention something here. I mean, suppose you're in a state which you know has bad creditor protection laws like New York or like California, and you don't want to incur the cost of having, say, an institutional trustee in Alaska or South Dakota or wherever. Some of the things you might consider doing are, one, you probably have a friend who lives in one of the jurisdictions. There are now 22, so you could add that person to at least be an administrative trustee, and then you may have a sufficient nexus to say this trust will be governed by the laws of the state of Ohio or whatever state you start for that purpose. I would not start in a state where you know you're going to be unable to defend against a self-settled trust claim.
It's a great idea. It's a great idea. More flexibility, more options.
And that right there, what Jonathan just said, is a good point of why we have these discussions with the clients, because each one is going to be different and the options that they have may present themselves from that fact finding that you have from talking with the client.
The last bullet point on slide 7, they're not putting a lot of money in these SLATs. They're putting, Jane's going to give $500,000, John's going to give $650,000. Different amounts. Will that help with the reciprocal trust challenge? Maybe, but it always looks better than having identical amounts. But these amounts are a pittance compared to what most people think you need to put into a SLAT. But for asset protection purposes, having something in an irrevocable trust, even if it's a home state irrevocable trust, done long before a claim arises, is a good thing. And as Tom explained earlier, they can make gifts and contributions every year. So now they have valuable asset protection plan. They can use annual gifts. They can make future gifts. They'll get income tax savings when Jane's mom passes with the step up. And Teresa, you'll have to help us figure out how to put in the basis, the GPOA to mom when we do it. I think we've discussed all of these things before. And what we're going to do is jump into the drafting in ILS. So at this point, we would have the AI summary stop the first memo, which would be in effect a memo about all the things we talked about to you, the practitioner. And now we're going to ask AI to draft a memo in less technical fashion to the client that points out all the different options and things that we talk about. So we created a hypothetical for John, and we're going to use a Spousal Lifetime Access Trust template from ILS to do it. And what we're going to do is run the document interview. And Teresa, Tom, Jonathan, please jump in, interrupt me. If I'm doing something wrong, just shout. So this is a standard ILS template. We filled it in before, so some of the stuff will be pre-filled, but we're going to talk about it. So for John and Jane, This is the Spousal Lifetime Access Trust. Tom, help me, I forgot my bearings. This is the one John is creating for Jane?
Yes, and this is the broader access template.
And by broader access in ILS, because of the differences between one SLAT and another, the broader access trust has more access to the assets than the other SLAT. And you'll see some of the differences as you go through it. So John and Jane, you need to be mindful that the trust John is creating for Jane will give Jane more access to benefit from the assets and the SLAT John's creating for her. And if in the future you do a SLAT for John that Jane creates, his access will be less than hers, so it's disparate. That's purposeful to try to address the reciprocal trust doctrine, but both of you need to be aware of the economic consequences that may create for both of you. And those consequences are important if there's a premature death, and especially if there's a divorce, and we'll talk about divorce again in a few minutes when we get to some of the other discussions. Now, this document is going to be in the home state, which we picked as New Jersey for John and Jane. We had a discussion with you of the benefits of going to a better trust jurisdiction, Alaska, Nevada, South Dakota, and others, and you opted not to incur the extra cost or complexity of that at this time, recognizing the limitations that that creates that we've discussed previously. We're including family information, we're listing children. Later, we may have a discussion about the definition of descendants. Why don't we add the ability to have insurance on the life of the grantor? By permitting insurance and having the John and Jane talk to your insurance consultant, you may find that some of the financial limitations or gaps in a non-reciprocal spousal lifetime access or SLAT plan can be addressed with insurance. So the risk of premature death can be addressed if there's an insurance policy. So for example, while Jane is alive, she's a beneficiary of the trust, and while Jane and John, while you are both married, John can indirectly, within reason, enjoy certain indirect benefits if Jane should take a distribution out of the trust and pay for certain types of expenses that may be for both of you. You need to exercise caution. But if Jane dies, John will lose access to this trust because there's no SPAT, hybrid DAPT, or DAPT type provision. So having insurance on Jane's life in the trust she creates may help make John whole. And the vice versa, having insurance on John's life in this trust will make Jane's financially whole if John prematurely dies and is not available to provide her indirect access to her trust. Now, we're not going to modify the crummy powers that are provided for in ILS because that's part of the distinction or differentiation between the two trusts for non-reciprocal trust purposes. John and Jane should be aware that there are crummy, C-R-U-M-M-E-Y powers in the trust, and if gifts are made, the trustee should issue crummy power notices, and because you're using a family trustee, you should probably speak to counsel to make sure those are handled correctly. We're going to provide a backup Q-tip marital deduction, so if any of the assets are included in John's estate on his death, they will be fall into a marital trust to qualify for the unlimited estate tax marital deduction. Now, in a sense, we're not that concerned about that because the couple presently is well below the estate tax exemption amount, but we're building that in for the future. And we anticipate that the trust will have GST exemption allocated to it, and we recommend that a gift tax return be filed by your accountant affirmatively allocating GST exemption, although we believe the trust should qualify as what's technically called a GST trust so that the automatic allocation rules would apply. From an income tax standpoint, the trust is a grantor trust, which means all income will be reported on John's income tax return since John is the grantor. Jonathan, briefly comment what happens so John and Jane are aware in the event of divorce.
one of the adverse changes that was made, and I think it was the
2017.
2007 tax changes, was that if you've created a trust for your spouse, it's going to be a grantor trust under Section 677, unless the spouse can only get a benefit with the permission of an adverse party, and that is not entirely clear. If you say, well, my son happens to be a beneficiary of this trust, and I'm going to say that, you know, my wife can get things only with the consent of my son because he's adverse. Case law, you can't read it in the code, you can't read it in the regs, but case law suggests that that may not work. So you need to consider that that just may not be the case. And that is a grantor trust under Section 677. And the adverse change I mentioned is that continues to be a grantor trust, even if you and your spouse get divorced. And you can imagine how unhappy a client will be if you say, Marty, I've got bad news for you, and I've got worse news for
Jonathan,
you.
let me interject. John, what this means to you is if you and Jane get divorced, you, John, will have to continue to pay the income tax on the income earned by this SLAT, even though Jane, who may then be your ex-wife, will be getting the income.
And that, needless to say, could cause a lot of consternation, and it's something that I feel strongly you need to double, triple warn your clients about. You know, they may decide that we'll take that risk, or maybe there's another trust which could make up the difference, or they may say that, well, at that point, we will say that Jane can get distributions only with the consent of an adverse party. But that's something that you really need to hone in on and warn the clients about, because it would make people very unhappy to say that they've lost access because they're no longer married to the beneficiary, but worse, they have to pay the income taxes on the income which is going to that spouse.
And these comments reiterate the explanations we gave you at our earlier meeting. The other point about a grantor trust is that the grantor trust provides significant flexibility, because as a grantor trust, you can get reimbursed for income taxes. You can have somebody in a non-fiduciary capacity loan you trust assets without having to post adequate security, and you can swap or substitute assets out of the trust. So if you are terminally ill and have highly appreciated assets inside the trust, you can swap them back into your estate for a basis step up. We're going to provide for a family's trust and make the
Marty,
distribution.
Teresa has a point to make.
Oh.
Well, I just wanted to check on the prior screen. When you spoke with the clients before, did you say or decide that Jane is a beneficiary always?
Yes.
Okay, so I think we need to change the option there on how we define spouse, because we've
I missed that.
Yeah, and I think if you change that to even after, I think you'll get an option about grantor trust treatment. I'm just pointing it out. Okay.
No, that's perfect.
Right,
and that's exactly why exactly why we draft with two people, because when you're using any drafting software, it's very easy to miss how or mischeck a particular option, and you don't get the result you want. So
yeah.
we had discussed at our initial meeting that you could have used what's called a floating spouse clause. So whoever John is married to at any point in time would be a beneficiary, and you were not comfortable with that. And what you opted for was that Jane will remain a beneficiary of this trust regardless of divorce. You understand the tax consequences that we talked about, and that is the arrangement that we're going to use here. And in the future, when your wealth is...
We could change the tax consequences there, because there is an option to end the grantor trust status right below the box. And so then you bring in the adverse party that Jonathan just mentioned. So that's an option, but we don't, as you mentioned, grantor trusts are still, a good idea. So maybe we don't want to do that here.
We don't want to do it for this client because we discussed it in the original meeting for John and Jane. And John and Jane have minor children. We're not certain that you will qualify as an adverse party, and they didn't want the extra complications. So we're going to leave that and move on. A family trust is being formed. So on the death of John, assets will be in a trust that can benefit Jane and the descendants. And we're going to give Jane a testamentary power of appointment over that trust. So when Jane and her will in the future can designate where those assets go, we've limited it to your joint descendants, so Jane cannot appoint to a new spouse.
Marty, scroll up for just 1 second. Go back to the previous screen. John and Jane, one of the differences in this trust is that this is a fully discretionary trust that John is creating for Jane. What this means is there's not a health, education, maintenance, or support provision in this trust. So Jane, as a beneficiary of this trust, could not serve as a distributions trustee because that would potentially cause estate inclusion for her. So that's one of the differences built in between the trusts.
But Jane, because of this, you will have more access to this trust as a beneficiary than John will in the trust that you will create.
And control, because there's also a lifetime power of appointment too, so that the ability to control things is greater here as well.
Now, we could change any of these powers of appointment, but the reason we're not doing so, as we discussed, even though they have important implications, is we want differences between the two trusts. When the last of Jane and John die, because the children are young, we're creating a single trust for all of your children. And then when the children reach the age of 21, we will divide the trust assets into separate trusts for each of your children then living. The idea, as we discussed, was that having a single trust for young children may make it easier to take care of the needs of each child, maintain a common residence or home without the complications of multiple trusts. And then after age 21, the youngest child reaching age 21, the trust will be divided into separate trusts, which we'll call descendant separate trusts for each of your beneficiaries. In the separate trust for each child, we're giving them a power to appoint by will, a testamentary power of appointment. And as we explained, that's a power where each child can designate in their will where the assets go. And we've limited that to, again, the descendants of both you, John and Jane. It could be much broader, but we did not provide for that here. If you want something broader or more limited, let us know.
John and Jane, we also included in that limited power of appointment surviving spouses of any of your deceased descendants.
And we're including supplemental or special needs trusts that will be triggered if any beneficiary is eligible for governmental benefits. Keep in mind that we're not aware of any special needs beneficiary now, and should in the future any of the beneficiaries have such needs, you need to reassess your planning. Default takers or takers of final
resort.
Final resort or final takers is if you and your family pass, the children are gone, and there's no descendants. Where will that go? It goes to the heirs of each of you under state law. If you wanted to name a charity or something else, you could do so. In terms of naming trustees, you named Uncle Joe as the initial trustee and Cousin Tom as the successor, and you should have different trustees in the trust that Jane creates for Tom and John, and we also recommend that they be independent. And we discussed that while some practitioners are comfortable having each of you be trustees of the other trust, that we think it may be safer not to do so, and you agreed with that. We're creating a provision called a trust protector and giving that person the power to change trustees among other powers. We can discuss a range of different powers that we could add depending on how complex you want to get and how much flexibility you want to build into the trust. Bear in mind, the more flexibility, perhaps the better ability for the trust to be modified to address future changes that we can't anticipate now. But the more flexibility that you build in, the greater the likelihood of somebody doing something you may choose to not have had done had you known. And you need to name a trust protector and need to name a successor for them as well. Now, the initial trust protector, you chose to name your longtime CPA, Carl, and he's been named. Now, one of the decisions you have to make is whether or not the trust protector will act in a fiduciary or non-fiduciary capacity. Jonathan, maybe you could provide a brief explanation of why John and Jane may consider a non-fiduciary capacity, and in turn also why they may prefer a fiduciary capacity. And what we've done in your document based on our prior discussion was specify that the trust protector will be acting in a non-fiduciary capacity. Jonathan?
Well, there's a big background to trust protectors, and I may be the first American lawyer to have used one, and I learned it from a Liechtenstein lawyer. That's really true, Marty. But the reason I don't think you want to have a trust protector act in a fiduciary capacity, especially where that trust protector has the power to remove and replace trustees, if something goes awry and you either claim that the trust protector didn't act fast enough or didn't do it the right way, that person can be personally liable. And when I was first asked to be a trust protector, I insisted that it be in a non-fiduciary capacity. Because you can think about every time, squabbles do arise and things, and you may not even be paid. I mean, one of the things you've got to think about is, should you put a provision in? But I think you're better off, whether or not you're going to have that person paid, say that they'll be acting in a non-fiduciary capacity to reduce their risk. I certainly, Tom and Teresa and Marty, I don't know whether you would act, but I would not act as a trust protector under an instrument where I was acting under a fiduciary capacity. As you can tell, I feel very strongly about this.
Let me make a comment. AI, when you do a summary, do not include the Liechtenstein comment to John and Jane. And that's important because you can comment as you do this and tell AI what you do and don't want in your summary or what to emphasize. And if there's a point that's really important, you can repeat it to make sure that it comes up. We've provided for, as we discussed, just reasonable compensation for the trust protectors. You did not want to get into a detailed discussion about what that may mean. We're permitting self-dealing between trusts. Family fiduciaries are allowed to self-deal and be compensated. We discussed those points with you at our meeting and just wanted to point out that that's what we've done in the document. The grantor trust powers will include the power to swap or substitute assets, which we've previously talked about, and that can be used in order to bring a high value appreciated asset, low basis asset back in your estate before death for a basis step up under current law. We've authorized the trustee to retain assets originally transferred to the trust. We've not waived the duty to diversify. We've authorized the ability to acquire unproductive property, which could include a residence, but you have to be very careful that if you do have the trust in the future by a residence, that there could be estate inclusion issues that could also undermine some of your creditor protection. There's a spendthrift provision in the trust, which is critical to achieving some of the asset protection that you wanted in creating this plan. But as we discussed earlier, you would be far better served in terms of just pure asset protection, having an institutional trustee and being in a trust-friendly jurisdiction. We're giving the trust protector the right to move the trust in the future to a trust-friendly jurisdiction and replace trustees so that you could get an institution there so that you could apply that state's governing law. Clearly, it's safer to start in a trust-friendly jurisdiction, but the cost and complexity dissuaded you from doing that.
Go back to the previous screen, Marty. In the document, we've added specific definitions for what your descendants are going to be considered in the trust. That will include individuals that are adopted before the age of 25, if they are any children born out of wedlock, and there may also be some additional provisions that we've talked about for assisted reproductive technology. You should review the definition of descendants at the end of the trust to be sure you're comfortable with what it says.
So at this juncture, AI, please use that middle part that we just finished, the second component. That will be for drafting a memorandum to the client explaining all the different options and decisions that went into the SLAT that John's creating for Jane. Now, I think we're done in terms of drafting. I'm going to just finish it up, but then I want to make some comments. So we're going to.
I need to make one too, if I can, while you
Yes.
change back to the slide deck, perhaps. You had
I want to
mentioned the
get this
power of
finished. I want to
appointment.
get.
Yeah, I
Teresa,
know.
we have to
Oh,
finish
yeah, no, you're good.
this.
I'm real quick. This is part of it, though. This is the power of appointment for, is it Jane's mom?
Yeah,
We
we
were going to
forgot
add
to
that
add that.
in, but there's not an option in the interview to flip that on. That is something that after we put the document together, we're going to need to add, because we don't know when she's going to pass away. And the way the document's structured, the trust is held in a one way while Jane is alive. And so we need to make sure the power of appointment for her mom is there if her mom dies while Jane is alive. And then if her mom dies later, we need to make sure the power of appointment is there too. So it would be something we would add manually after we put the document together. So I just want to make that point, because that was one of the important factors.
So AI, please include the comment that was just made in appropriate tone to the client that we've included the power of appointment we discussed for Jane's mother. And also mention that in the first part of the memo, the first memo to the practitioner, based on our initial discussions, that is one of the items to tailor to get this planning to work as we discussed in the hypothetical. So let me make some general comments. The back and forth that we had, part of it is, it's a little more nerve-wracking doing this while I got Jonathan and Teresa and Tom looking at me, and also all of you. But the dialogue is helpful, and what Teresa just did is exactly why I think if you try drafting on a Zoom meeting or a Teams meeting, whatever you use, with a colleague, you're going to find the colleague catching stuff that you didn't have. And I promise you, if you have Jonathan draft with you, he's going to give you lots of thoughts that you didn't have. But that's the beauty and power of ILS on the opposite end of the continuum of doing a template to do it really quick. And I'm not negating the value of that for many clients. I'm offering another option. But I think in about a half an hour of drafting, we've talked ad nauseum, no, take that out, AI, in detail about many of the different options in ILS and how we tailored this for this specific client. And it may very well be that every trust we draft for every other client is going to be somewhat different because we tailor it, like, for example, the GPOA to the mother, or maybe some of the decisions we made, or the definition of descendants. And different clients may have religious issues or family health issues, and you may want to modify for that. To the extent you can do it in the drafting session, all the better. And this is like what my mom always said, 2 heads are better than 1. And that's why we like it. But you'll also see when we come back, if everything worked, we're going to demonstrate how AI can create a memo to send to the client explaining all the things that we discussed.
I'd like to make one point, Marty, one more point, and AI, you should include this in the first summary to the practitioners. When you are having these conversations, you need to speak in a certain way. So just like how you are training the AI, you need to train yourself to talk in a way that helps the AI create the summary. You will see in the transcript to John and Jane at a later point that Marty and everybody else has spoken in a certain way that helps make a better product. I liken it to how there were certain ways in the past you would speak when doing dictation for somebody to write a letter up for you. Just like how you were trained in dictation to speak a certain way, you're going to learn to speak in a different way that helps the AI give you a better product.
And Jonathan has not done this before. So when Jonathan is explaining something of how he viewed something or what he may have done, that's valuable information, but it's got to be couched in a way of, John, you should consider that making the trust protector in a non-fiduciary capacity will give the trust protector better liability protection and more comfort making the decisions you need. So you, the lawyer, have to learn how to do this, and it just takes a little practice. And maybe it's repeating what Tom said, but I think it's a really important point. And it took us a while to figure this out doing meetings where we were recording it. It's not just about training the AI, and I'm going to explain that in a second before we go, or Tom can, but it's about training the lawyer to use the AI the way you need to get a better result. The better you get at communicating to the AI, the recording of the meeting will give you a better result with less time and less cost. Jonathan, I know you have to run. I just want to take a minute and talk about AI prompts, but if you have to leave, I'm going to let Tom talk about that, and then I think we're done.
So
I've got
AI
a few more minutes. Marty, I've got a few more minutes, so go ahead, please.
Do you have any comments you want to make?
No, I think,
You
Marty,
having fun?
you probably did take only 15 minutes.
By the way, but that's the power of drafting software. You can customize a sophisticated SLAT for a client of moderate means, and if they get a basis step up when an elderly a parent or somebody passes, that's a home run, even if there is no estate tax forever.
I also think the more you do this process, the quicker it will be, because you'll be used to working together. You'll be training yourself on how to speak, even though I'm wondering how many in the audience don't know what dictation is. I do, I'm that old. But you'll also just be used to, you've had the same discussions and it's a different client. So you have to have the discussion again, but it's more of a rhythm. And so I would encourage you not to give up. If you do it the first time and think, well, I'm not sure how efficient that was just the first time. Just as Marty, you said, it took you a while to make it, the way it is now, which is efficient.
The first 3 or 4 times that we recorded a web meeting with a client and tried to get AI to draft a summary of it, it was so bad that I reverted back to using my old note-taking. So yes, it takes some practice and thought. But what's fascinating about this, it's transforming how we practice. If you can draft a really sophisticated SLAT, forgive me, Jonathan, in 30 minutes, not 15, and you can get a pretty good memo to a client with an hour review. You can't send anything out without reviewing it. There will always be mistakes. But if you can draft a SLAT in a half an hour with 2 lawyers on the meeting and get a memo in an hour or so done to go with that, that's an incredibly powerful value add for an awful lot of clients that are probably off the sophisticated trust radar screen, and they don't have to be off that screen. So one of the things to do, and we're going to try to illustrate this, and again, this is an experiment in demonstrating the process, so bear with us, we're trying to make it work. One of the things that's really critical, and we're not going to get deep in it, we could do a whole program, and we will do a whole program just on AI prompts. The way you frame your question and directions and instructions to AI, we call it AI prompts. I've heard other names used, but what input you put in when you give AI the transcript is critical to the output. So one variable is the way you speak, and one of the things which is obvious because it goes back to dictation. You can't have 2 people talking at the same time, and if that happens in a meeting, you got to say, this is what was said, or summarize. And the second is putting thought into the prompts you use. Tom, just in 1 minute, because I know we're pretty much out of time, just explain a little more detail what a prompt is, and we'll demonstrate that in the next session, or the latter half of this session.
A prompt is the set of tasks that you are giving the AI to do. So I liken it to giving a admin assistant or a lower level associate instructions on what you want them to do with a certain task. When you are doing a document, or if you're doing a summary, a good portion of the time should be spent thinking about the prompt you're going to create. If it used to take you an hour and a half to do a memorandum, maybe you spend 15 minutes creating the prompt and 45 minutes reviewing the result of what you get from that prompt. By putting the time in beforehand to create the instructions for the AI, it's getting you a better result that's more usable with less time invested at a later point. One example that I'll use is just the formatting of what you actually want. Oftentimes we found AI likes to put lines between different paragraphs. So we have in our standard prompt, please don't put lines between any paragraphs. Do not bold random language in the document, only bold headings. We've found as we've created these documents, things or idiosyncrasies that the AI will do, and we've specifically modified our prompts, which we have saved in a document to affect and to create a summary in the way we want it to be done. So it's a living, breathing prompt that updates and changes as you are working with the AI.
And we modify it probably every week. And we have a series of different prompts. We probably have like 8 or 10 for different functions. And we'll show you some of the prompt we use when we see how we generate it. And before we conclude, AI, when you create 2 memos out of this transcript, the first memo is about all the discussions at the beginning and this little bit at the end to the attorney. And the middle part is the memo to the client. Be sure when you draft the memo to the attorney, you speak in the voice that a technician and a sophisticated estate planning attorney would use. When you draft the memo to the client, please speak in a less technical, understandable voice that a sophisticated estate planning client will both understand and be comfortable reading. I think we're good with this segment. We have no idea how this is going to come out, but that's what our experiment is. And what we plan to do for part 2 of this drafting session is we're going to try to generate the transcript from this webinar, get a memo generated from AI, and hopefully not a lot of time, show you how we did that and what we did. And Teresa has got a Harry Potter's magic wand. She's going to glue with special glue, electronic glue, this webinar together with the session where we show you the output, and we're going to give you the output in the handout section so you can see how this all fits together. Let me summarize real quick, and then I'm going to let Jonathan, because I know he's got to go, and then Teresa and Tom can also add in. What we've tried to demonstrate is an approach that for certain types of clients we believe is very effective. For the moderate wealth client, we simplified it, but we were trying to illustrate how even for a smaller, simpler client, in 30 minutes, interactive discussion, generate a memo, robust tailored documents, that's the power of what technology can do, and how I feel one of the ways it's transforming how we serve our clients. Jonathan, comments, thoughts?
Marty, I think if people try to adopt these things, it will make their practices much more robust.
It's exciting, isn't it?
It certainly is.
And for the record, everybody, I think it was 2010 at Heckerling, Jonathan talked about the future of the practice. Everything he predicted, from paperless offices and no conference rooms, everything he said all came true. And this is, AI is something I don't even think you had on your radar back then.
Well, I think I had a form of it, Marty, but not what we have today. And I'll tell you, in 2 years, I think it's going to be entirely different again.
Yes. Teresa, thoughts?
Yeah, I was just going to add, since you were talking about the prompts, we actually had a meeting earlier today talking about AI in different ways. And someone made the comment, because some of us were still struggling with how do I, maximize my use of AI with what we have, with the tools we have right now, recognizing they're going to change. And someone who was actually doing that made the comment that you really are treating it like an employee in a way. So you're talking to it like an employee, like Tom just mentioned, someone that you're delegating a task to. And so start there, and you may have to then refine, just like if it was an employee, you may have to say, okay, I see what you did here, but let's tweak it a little bit. And so that was the advice, and I think that could be helpful. Think about it as if it were a person to which you're delegating a task, even though it's not a human, and that can be a good starting point for feeling how much you have to explain and modify.
What we do is we use Outlook for contacts. We created an Outlook entry, now I'm telling you the secret sauce, called AI prompt. So if I'm drafting something, I bring up the AI prompt in Outlook, just like a person, like Teresa said, and I look down it, and we have like maybe, I think, 8 or 10 different types of prompts we've created, because for different tasks, we have different prompts. And I have a prompt that we've worked on and continually modify for creating a memo out of a transcript. This memo, we're going to create two, one for professionals and one for clients out of the drafting session. So it's going to be a unique thing, and I'm going to have to tailor the specific prompts that I use. I'm not going to change the standard prompt we have, because this was a webinar trying to demonstrate it, and I'm never going to have combined these two types of memos out of the same process in the future. But by having it in Outlook, anyone in the firm can open it up, and if they see a place to modify it, they can modify it. And just because we know stuff happens, I won't use the stronger phrase, every now and then we copy all of our AI prompts into a Word document and save them in a special folder. So if somebody gets bad and tinkers with it in a bad way, and I said, no, I like the way it used to work better, we can go find it. Any final comments, or I think we're good with this part of the
One final
more
comment that I have just about AI and what we've done here. Hopefully what we're demonstrating, and when we get to the summary, if this works the way that we're planning on it working, is we're showing AI as a force multiplier, but it's not replacing the judgment of the attorneys as we're drafting. It's being used in tandem with the decisions that we were making as we were going through the process of drafting here.
And in theory, we'll hear that next piece right after we finish this one.
Fingers crossed. You can leave that in the tape. Fingers crossed. We'll see. Thank you, everybody. We'll see you in a few seconds in the final part.
Hello, everyone. So you have just finished watching part 1 of the SLAT drafting workshop. And as Marty indicated, we are going to now jump to part 2, which happened several days later. And so we recorded part 2, but I wanted to give you a bit of a you are here kind of orientation on the roadmap of this presentation. So we had the first hour, and we went through essentially a drafting workshop. And as I think we'll talk about in this final section, you won't always do that with 4 lawyers. We had 4 lawyers on this, so there was a bit more discussion than you would probably otherwise have. But we will talk about the benefit of having 2 lawyers do that if possible, just because 2 sets of eyes is a great thing. And so we'll discuss that. But after that session, as you'll hear, we took the transcript, and then it was used to generate a client memo. And what we did was we made some edits to the memo, but not a lot. We didn't edit it for the final product either. We wanted you to see exactly how it was generated. So if you grab the handout, or if you already have, you will have a copy of that memo that was generated from the transcript with some of the changes tracked. Again, we could have cleaned it up even more, but we wanted you to see the process because, as Marty will explain, it's an evolving process, and the prompts used to direct the artificial intelligence that is creating the memo will be refined, and we'll do better next time. So just keep that in mind. So once I stop talking here, you will be joined by our group again. Jonathan Blattmachr was not able to join us for the final bit, but Marty and Tom and I will talk about the product, the memo that was produced, and the overall drafting process. So I hope you enjoy part 2.
This is part 2 of a 2-part webinar series. The first part was drafting a SLAT. And what we did was try to demonstrate different concepts in how you can draft a SLAT using, Teresa, what did we use?
We used InterActive Legal. Now, you could use any drafting software to do this, but that's the one we have. So we use that as our example, right?
So yes, we used ILS. So all the templates, anything you'll see on the program was from ILS. It works for any drafting software. So some of the, just to review very quickly, some of the key concepts we tried to demonstrate. 1, we didn't have one lawyer or one associate draft a document in the room alone. We didn't have a preset list of options that we decide and use for all our clients and have a paraprofessional bang out a a SLAT using a form template so that every client is kind of the same document. What we did is we have multiple lawyers, and you can do it with two. We happen to have Jonathan and Teresa on the phone, and Tom and me. So we had a little party, but you can do it with two people. The concept is if you have two people drafting a document, when you go through any drafting software, the dialog boxes give you options. Instead of just boom, 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 selecting an option, we're using the prefab where you can pre-select options ahead of time. We went through each option. I don't think it took more than an hour with all of us chit-chatting about it and making discussions about which options to choose for what. We had a hypothetical scenario of a moderate wealth client, which is, again, different from what many people talk in the profession. And I think it's a very useful, practical, and beneficial way to take sophisticated SLAT drafting down to the mass affluent client. So you can do this kind of work for lots of clients, whatever your level of profession. And with ILS or any drafting software, we did this in like about an hour. You can do it faster as you get more efficient. So the concept number one is SLATs can be used for all wealth levels. They're just applied differently. And we talked about the assumptions to make it more cost effective. Concept two, having two professionals on a Zoom meeting while you draft, you have the discussions. Well, why do you want to not address divorce? Or why do you want to have the spouse removed in the event of a divorce? That discussion gives you a better result. And what it does is it makes the whole process less costly, more efficient, and better for the client. Because when you're discussing it as you go through it, one person can't just make a decision or an assumption. You have somebody to counter it. So if I check something Jonathan didn't like, and you all who know Jonathan know he's never been shy, he spoke up and said what he did or didn't like. And in some cases, I said, well, Jonathan, that's what the client told us at the meeting because it was a hypothetical. But the point is you get the input now so you don't make revisions later. You have it done up front. Very efficient. Different than what I think many people use. Now, the other thing we did, we recorded the meeting, and that's what we're going to show you what happened with that in this quick supplement. By recording the meeting, our goal was to create a client-facing memo that does a bunch of things. Number one, by giving the client options, instead of saying you chose at the meeting not to address divorce in the SLAT, which many clients do. That's what my wife and I did in our SLATs. We didn't care. But we talked about different pros and cons and options amongst us as we were doing the drafting. By doing that, that's all recorded and becomes part of a memo to the client. So you may have a default that you like to use a limited power that's limited to descendants of the couple. That's fine. But when you're going through the template, the drafting software template gives you lots of options. You can say, Mrs. Jones, we didn't use and name the options. We instead felt, based on our discussion, that this option was appropriate. So that discussion memorializes for the client options. When the client gets a memo, it's now on them. If they don't like the assumptions you made, they can tell you. They can't come back, or their kids can't come back and say, oh, you shouldn't have done that. Hey, we gave you options. It also empowers the client because you're explaining stuff from a different lens. Most of us don't explain to the client all the default assumptions or drafting conventions we use in a document. But the process that you saw illustrated in the prior webinar, we did just that. So the power of drafting software, and again, we used ILS, but it should be with any, is the template has invaluable information that you can discuss in the context of what you did for that client. So Tom, why don't you make any comments you have, and then I'm going to show people quickly what the output is, what we did, and why I think this is so helpful. Last point that I missed that's probably the most important in my view, it's protective of the practitioner. By us sending another memo that explains not only what we did and why we did it, but what we didn't do and why, I think it's incredibly protective from a malpractice perspective. There's a lot of talk in the profession about the reciprocal trust doctrine. Now divorce and SLATs has become a hot topic. We talk about it. Now it's on the client. We gave them options. Tom, why don't you make some comments and thoughts, and then we'll have Teresa comment and thought, and then we'll look at our documents.
So just
which, by the way, will all be on the web portal, so you can download them.
Couple of quick comments about the flexibility of the use of AI when generating this report, because we've created this from the transcript that we have from the first portion of this recording. How this comes out of the AI, though, depends a little bit upon you as the practitioner, how you craft your prompt, and what you want it to say. One of the strengths of the AI is that it can adjust its language, the voice that it talks in, the way that it structures the particular memorandum that's created from this, so that it's similar to what you've created in the past. It's what your particular practice wants. However, doing that will take some trial and error. You'll have to craft your own what's called a prompt. That's the parlance with AI. It's the instructions that you're giving the AI when it generates the memorandum. Think of it as like when you're talking to a paraprofessional or a low-level associate when you would originally have asked them to create this memorandum. You're giving it the instructions, and that can go down to how you want the headings to be set up, what kind of language you want it to use, what kind of paragraphs you want it to use, and that's going to take you some time. But as you use this and as you get more proficient with it, your prompts will get a little bit longer, but the result that you get is going to be more detailed and closer to what you want. So the efficiency from the very start, it's going to be greatly efficient because you're going to get a product that you then revise. But as you go on and you get better with it, the efficiencies are just going to compound.
Teresa.
Yes, well, and that's the example that we have is the memo that was produced via the AI prompt that we used, but it also shows all the changes we made. And at the very beginning of the handout, it talks about, here's what we now realize we should have done a little bit better. And so that's exactly what Tom was saying about refining the prompt. And so we realized some things we could have done better, and we'll do that next time. But for now, we edited that in the memo, and we're showing you the edits we made, so you're able to see, what the actual generated product was, which was decent, but then we fine-tuned it quite a bit. I was thinking about prompts because prompts can be long, but again, they evolve over time. One thing that we did when we were recording this drafting session, I think it was hard for me to pretend I was talking to the client. So the memo is written to the client, but the discussion between the attorneys, I suppose you could let's pretend we're talking to the client, but that's hard. And so I think the AI prompt can take your discussion and convert it into that memo to the client so that you get the audience right.
Not meaning to insult anybody, but Teresa raised a great point, and I'm going to say it more bluntly. It's not only about training the AI, which means the prompt or input you use. It's about training who, Tom?
Us, the practitioners.
Yes. But
True.
as you work with this tool, my belief, and this wasn't ILS's belief, but my belief is that you can really apply ILS or any drafting software in an incredibly different, creative way that gives you better product, more sophisticated product, more tailored to the client, and more instructive and informative memos for really modest cost. I think it took us about an hour to do the first webinar. Had we not had as much chit chat or as many people, and we were more down to business like you will be in practice, you can draft a sophisticated spousal lifetime access trust with upstream basis planning, asset protection benefits, and so on in 45 minutes. The cost of
and
that
without it being cookie cutter. That's the thing.
Yes.
And I was when you were talking about this with the memo for the client that says, this is what we did and why, and these are some decisions for you to make and why, and here's what we didn't do. All of that, I think, shows the client, because so many clients out there think that this is cookie cutter. And why is it so expensive? You don't have to think about all these other issues, but we do. And this shows them all the other issues that we considered and we have to consider. So it's helpful for the client to understand the value they're getting in addition to protecting the practitioner.
That is
one last
brilliant
comment I want to make quickly, Marcus. I do need to drop off based upon what Teresa just said. When we first started using document generation software, we saw a sea change in how we had relationships with our clients. It went from probably, I would say, 80% of the time spent drafting the document, 20% talking with the client, to almost an exact flip of that, where the vast majority of our time was spent discussing with the client what we were creating for them. They saw more of the time that was put into what we did. And that actually helped our relationships with our clients reduce complaints by the cost of the fees, because they saw so much more of what we were doing. By practicing in the way that we're talking here, it's creating a greater level of discussion with the client. They're seeing more of the work. That's not just protective of the practitioner, it helps that relationship with the client and may reduce complaints that you have in the future. So it's a win-win for everybody in that situation.
Before you run, Tom, I want to quote a very famous estate planner and the phraseology that he used about what you and Teresa just said. His name is Emerald. You didn't know him as an estate planner. You thought he was merely a chef. What he said is kick it up a notch. And that's exactly what I think this does. It kicks up your practice a notch. And Teresa, Tom, I know you got to run, so run. Teresa's point was brilliant. I hadn't thought of it. But yeah, what you're doing now is you're allowing the client to look behind the curtain, think Wizard of Oz, and they see the levers we're pulling. It gives them a different appreciation. When you go on to one of these online form generation services, or there's a lot of practitioners that have a standard form and they have an admin person change the names. They can't do what we're talking about. But with ILS, it took us, let's call it 45 minutes reasonably to draft a very sophisticated SLAT with, as I said, asset protection, upstream planning, possible estate tax if they lower the exemption to 3.5 million is proposed. It also maybe 15, 20 minutes of tinkering with AI to get like an 8-page memo to the client that did exactly what Teresa said. They could peek behind the curtain, protects us, informs them. It's a roadmap for the people using this trust in the future, whether it's the accountant, the wealth advisor, et cetera. What a great way to inform everybody of all the detail and the decisions and the thoughts that went on. You've created a great roadmap. I would say, and we tinkered back and forth because it was new for some, but I would say that memo in an hour and a half, maybe 2 hours could be reviewed. And yes, you do not send anything out AI generates without reviewing it. And you're going to always tinker with it because you have different nuances or spins or emphasis than what AI might pick up. Though the more you practice, the closer your output is going to be to what you want. But let's say it's 45 minutes to draft a sophisticated SLAT, 15, 20 minutes to get the AI memo, hour and a half to review it. Think about billable time, what that cost, and the incredible product you're generating. Teresa, I'm going to bring up 2 things if my computer cooperates. All right, let me try to minimize this. So can you see the SLAT transcript?
Yes. So this is the transcript from, it was a webinar it was the first half of this webinar, the first section of this webinar that we recorded, and then we used this as the basis for the memo.
And just so you know, this is almost 12,500 words. If you look at the first couple of things, it's kind of like gibberish. Names are spelled wrong. This is not usable. If you gave this to a junior attorney and said, hey, draft a memo out of this, you'd be talking 20 hours a time, 15 hours a time. And it's a massive undertaking. AI, and it's not instantaneous. I think some people think you plug it into AI and bam, you get something. No. And by the way, and this is important, if you use prefab software, and there's a lot of products coming out like designed for lawyers to do all this, those aren't your prompts. They're the prompts of the developer. Now, I'm not saying that's not good, and I'm not saying it doesn't give you a leg up. But if your practice is focused primarily on people under 10 million, and you're doing a lot of revocable trusts, and you're doing SLATs for basis step up from moderate wealth clients, your memos and your analysis and your prompts are going to be very different than someone that barely sees clients worth less than 50 million, and most of their clients are 100 million and up. Very different. The prompts need to be different level of client. So what I did is I uploaded the transcript that you just saw, which was seemingly useless, in 12,500 words, and I got back almost, I'd say, a 3,500 word memo. Part of the word count is these instructions, and this is all going to be posted to the web portal so you can see everything we did and why we did, and I explain everything we just talked about here and more. Here's the memo, and you see some of the explanations. Now, one of the things I can say, the tone, and this is my fault, my prompt wasn't good. It's always a learning experience. AI kept saying, you discussed. I don't want it to say what we discussed. I want it to speak to the client. And I thought I had a prompt that did that. I didn't. I've revised it a couple times since. I'm going to revise it again. You need to get the tone right. But I decided, you know what? I'm not going to fix the prompt and revise the memo. I want to show you, the bad stuff too, so you can see even with a lot of mistakes in the prompt, you got a really useful memo that took 15 minutes to write. And as your prompts get better, you're going to get closer. Now you see a lot of red here. That's because we updated and changed things and thought of things that we needed to do. I asked it to give an executive summary. I asked it to give action items by person. So for example, it broke them out by you, which meant the husband and the spouse, the wife, but they're together as the client. So I got rid of that. The insurance consultant, every different advisor got a checklist of what to do. And then we go through, we talked about non-reciprocal trust, funding and timing, different access distribution points. That's important because if you do non-reciprocal SLATs, which we contemplated, but we only did the first spouses, those different distribution standards are really critical for the clients to understand because they have real economic substance, which is the whole point. Divorce, Jonathan was especially concerned about divorce and berated me for not focusing enough on it. It's not that I didn't focus on it. I said that in our hypothetical, the clients weren't concerned. Some clients aren't, some are. You handle it however you choose, but we have lots of stuff discussing it here, and that's probably why that section saw more rewrite. We talked about life insurance. If you're funding a SLAT and there's a premature death, life insurance can make up that difference. We talked about timing and funding, disposition on death, what happens, special needs, default takers. A lot of these captions are conceptually right out of the interactive legal drafting template. And that's a natural because we were reading them and talking about them. We didn't read them, we talked about them. And that's what was recorded, and that's what AI turned into a memo. So, Teresa, I'm going to stop and let you make any final comments, and then I'll just summarize. And I think we're good to go to demonstrate what I think is a fascinating new way to approach drafting and a fascinating new way to approach communicating with clients in defensive practice. And I love your idea that the client now sees the thought that went into this, which a lot of times you may have assumptions or standard language you spend hours and hours developing. Client doesn't know that. Now you're telling them.
Right. Yeah. And I don't know why one of my favorite terms is bespoke. They end up with a bespoke document, and maybe this helps them see that. Now, I still am not opposed to the idea of, having, clients in certain groups, the ones that don't care about divorce and the ones that do, and, the ones that care more about asset protection and the ones that don't feel like that's an issue, although that's probably an issue for everybody. But I think you probably could still, have some defaults, especially when you get down to like the boilerplate things, like we're always going to include substance abuse language just because, and we may not even need to talk about that, but all the things that do need to be discussed, you can have a standard default, but as you're going through the program and drafting, you have a checklist, and so you almost can't forget an issue. But if you overlook something, you've got the other attorney there who is, you've got a check and a balance, you got two sets of eyes. So I think that really, really helps. I was going to say that the two handouts should be available to just download as well while you're watching this.
They will be.
You haven't done that already. And yeah, this one has a lot of red, but everybody writes things differently, and a lot of this red stuff, it will be fixed the next time because we'll refine the prompt. So showing you this is, showing you it's a work in progress, even for a firm like Marty's that's been doing this for a while. And I'm trying to think. Oh, the other thing I was going to say is that Emerald also says BAM, and I was trying to figure out how you were going to work that in. And I heard you say BAM just a minute ago. So I appreciate that.
So a couple of very quick comments. So great point conceptually. So let's say your practice does a lot of moderate wealth clients that efficiency is the most important thing. And what you've done is you use, and I know you can do it in ILS, I assume all the software packages permit it, where you can create a template for a SLAT or a Rev Trust. That's fine. What I would do is do a drafting session, just like you previously saw in the first part of this program, and talk about all the defaults. That now becomes the default input for a standard memo, because now you don't see them or talk about them because it's embedded in the program. And if you pick and set up your own customized, let's say, revocable trust in ILS, because the bulk of your clients are in one category or one, range of categories, that becomes the default. You just paste in, and now you got a standard memo. And when a client is different than the category and you're doing using the full template so you can discuss all the options and doing a more tailored plan, well, then you do just what we just demonstrated. But this thing can be modified for wherever and however your practice is. And we try to stress the moderate wealth client. But obviously, what we just demonstrated for a client worth 100 million and up, this is a phenomenal way because you're giving the family office, the other advisors, really an insight into everything you did. We may have to post these as PDFs because I don't know if the system will accept a Word document, but it'll be there. It demonstrates everything. And I hope, if nothing else, at least it gives you food for thought to think about how you might grow and change your practice to address and incorporate technology and now even AI.
Yep, it was fun too. I enjoyed it.
Okay, it's fun. I can't say anything more. All right,
Well,
thank you,
thanks.
everyone. Hopefully this was helpful. Take care.